Swayam Prabha. Digital India. Educated India.
Dear students, the last part of the class which we will discuss about the regulation of combinations and which we talked about, which is the third part of the competition law, and this is the last part of the competition law. And combinations, what is the combinations? And combinations are nothing but which is described in the section 5 of the Indian Competition Act. This is with reference to combination of companies, and basically these combinations of entities in order to eliminate the competition from the market. If two enterprises are joining together for eliminating competition from the market, then it will be considered as violating the Competition Act and competition provisions. It is against the competition in the market. So, the Competition Commission of India procedure in regard to the transaction of business relating to combinations regulations was passed in 2011 under the Competition Act of 2002, and specifically the business combinations are mentioned under section 5 of the Indian Competition Act. It talks about if acquisition of one or more enterprises by one or more persons, or merger or amalgamation of enterprises shall be a combination of such enterprises and persons or enterprises. Amalgamation or merger or per se is not illegal under the Competition Act. So, the companies can merge for different reasons. Their amalgamation also will be there for business purposes, but all these are not violation of the Competition Act, but we have to look into what kind of business combinations are violating the Competition Act and competition law. And the business competition, the merger, if you look into the merger, you can see that the two companies merge together and to form a new entity. So, it means that one company completely loses its character, its legal character, and it merged with another company. So, it means that the competition, even though it can be between the competitors, it can be subsidiaries, it can be with some other business competitors. So, especially if mergers happening between business competitors, then definitely it has to be under the scanner of the Competition Commission of India to see that what were the objectives of this particular merger. So, merging companies, basically once it is merged, its autonomy is completely it's lost or ended, and the acquiring company is going to take charge of the affairs of that particular company. So, it is basically, if it is for the acquisition is basically for eliminating competition from the market, then definitely it is against the competition provisions or Competition Act, or in order to, or competitive process in the market. So, always the interest of the society has to be examined in business combinations. If you remember the first class itself, I have mentioned that the objective, the antitrust law in the United States has come up mainly to eliminate the trust, which they become huge entities, and to have a monopoly power, and they are gone for the mergers and acquisitions again and again for making huge entities, business entities, in order to eliminate competition from the market. And then broadly we can see that it is basically to acquire control of another company. It can be through the share purchase, it can be the voting rights, it can be purchase of assets, it can be the acquisition, it can be over there are various methods of the acquisitions, various methods of acquisition of power controlling a particular company, which is elaborately mentioned under the Companies Act. At the same time, our point of discussion is that whether these mergers or acquisitions or amalgamations are affecting competitive process. This we have to look very closely, and the competition regulations 2011 regulations, which put certain threshold limits of mergers and acquisitions, and beyond those threshold limits has to be, if there is a merger or acquisition, you have to inform to the Competition Commission of India, and the Competition Commission will look into the merger and you have to take a prior permission. And these thresholds which will prevent. So, the basic objective why you should inform to the take a clearance from the Competition Commission means the Competition Commission very closely look into whether it is going to affect the society at large or whether the consumers are going to be benefited. And also these threshold limits which is prescribed by the 2011 regulations will be revised from every 2 years by the Competition Commission of India. And Section 6(2) of the Act clearly says that acquisition, merger and amalgamations these beyond these threshold limits must be get a notified approval from the Competition Commission of India. And these limits and the Competition Commission, there must be a notice period and is there in which you can inform to the Competition Commission. So, the proposed combination 30 days of approval, and the board of directors you have to inform to the Competition Commission of India. And the combination, if you look into the combination conditions, you can see there is the combination conditions must be definitely for a period of time, and which will for the benefit of society at large, benefit of the consumers at large. So, that means they have to the parties of combination has to report to the Competition Commission of India. And otherwise the Competition Commission will always look into the investigate if the Competition Commission of India have a prima facie opinion that this combination is likely to cause or caused an appreciable adverse effect on competition in the market, then they can start an investigation into such kind of combinations. And this inquiry into the combinations involves evaluations of certain factors. These factors include identification of the relevant market consisting of the relevant product market and relevant geographical market as well, which we discussed in the last class about what you mean by the product market as well as the geographical market. Then again whether these combinations have an appreciable adverse effect on competition in the relevant market, that is in India. And these combinations, the Competition Commission, according to the approval of the Competition Commission of India, such modifications can be made for the mergers or acquisitions of by the enterprises. And the how to make this relevant market and product market, which we already discussed. And the relevant product market, it is very important to look into the relevant product market as well as the geographical market. And the product market is very important because the product may not be available in other parts of the geographical area. Section 19(7) of the Competition Act, which provides an indicative list of factors that has to be taken into consideration by the Competition Commission while determining the definition of the product market. And these factors are the physical characteristics and end use of the products, then price of the goods and services, consumer preferences, then exclusion of in-house production and exclusion of existence of specialized producers, then classification of industrial products, and all these are the factors to be considered by the Competition Commission of India when considering the commission. And also it is the duty of the Competition Commission of India to look into the effect of appreciable adverse effect on competition. And again you can see that under section 6 it is very clearly said under the section 6 of the Act, no person or enterprise shall enter into combination which causes or likely to cause an appreciable adverse effect on competition in the relevant market in India, and such a combination shall be void. So, it is very clear that if there is any appreciable adverse effect on competition in India, then it is going to be a void combination. Then again we can the notice and other things which are the regulation 9(4), which talks about, which provides that the parties can file a single notice in case of multiple business transactions which are interdependent or interconnected to each other in the case of mergers or amalgamations. And definitely so we will ask why there must be the combinations or amalgamations. So, there will be different reasons for going for mergers. This may be to acquire a new market, maybe to eliminate a competitor in the relevant market, and also these mergers acquisitions have there must be expanding strategies of the dominant player, also one of the reason for mergers. Then these entities which you can see that this can be considered as joint organizations, the merged one and the merging one, and this may be takeover of this entity by the other also will be considered as if it is for elimination of competition from the market, it will be considered as again these combinations will affect the market, then it will be violation of the competition provisions. Again the purpose, the appropriate legal structure essential to ensure the combination. So, that means it is exclusively following all the legal parameters, then it cannot be considered as anti competitive in nature. But again the forward looking analysis has to be done by the Competition Commission of India in every case, and also look into each and every factor involving in this particular mergers also can be looked into for whether there is really these combinations are anti competitive in nature. So, if you look into the combination, it can be horizontal combination, it can be non horizontal combinations, and it can be vertical combination, and also it can be conglomerate combination as well. So, horizontal combinations, if you can see combination between firms at the same level of production, and which we talked about, the horizontal level will be always at the same level of production or distribution. And the implication is that in the case of so one firm, one enterprises will be going out of the market by this horizontal combination. So, the post merger firm has a larger market, a larger size, and also have a larger influence on the market. And the negative effects, if you look into the horizontal agreements, which you can see that there is a coordinated effect. So, the coordinated effect of or combination increases the probability of less competition in the market. Then and also it can arise the competition between the products of the combining firms and eliminated allows the combined entity to unilaterally exercise the market power. That means, the product choices are also eliminating from the market. And in the case of non horizontal combination, we can see that it does not entail loss of direct combination and generally not anti competitive in nature. And here also these both the consumer as well as the administrative, which you can look into, and also the vertical combinations and conglomerate combinations are also also important in the case of combinations. And in the so horizontal, which we saw that the combination, and vertical combination will be always operating at different levels, but complementary it can be also at the complementary levels in the chain of production or distribution. So, vertical combinations may be at the different stages, they may operate at different stages, and generally between parties that that generally do not currently compete in the same relevant market. They may be in the different market as well, it may be product market or geographical market. And but competition law generally those do not have any kind of objections to the vertical combinations, but if these vertical combinations which affect the markets or to eliminate competition from the market, or it may these kind of combinations result in foreclosure of the market, such source of or to eliminate the competitors from the market, then definitely vertical combination also will come under the purview of the competition law. So, the specific objection, what are the objections to the vertical combinations is that, and here you can see that the Raghavan committee, who is instrumental in drafting this particular law, identified 3 problems with the vertical integration, that is the fear of foreclosure, and then entry blocking and price squeezes. And again the fear of foreclosure, as we already said that the vertical integration it can create captive distribution channels. So, this may foreclose the rival firms from the market and ultimately they may go out of the market. Then entry blocking. So, entry blocking through vertical integration, here the firms will be able to internalize different level of production and the artificial barriers can be put in the market or the entry of the new entrant. And price squeezes always look into the firm to reduce the cost. So, this will result in the reduction output prices and generally the price skews, and this also will be considered as the eliminating the competitor from the market. In the case of conglomerate combination, it is a combination between firms that operate at the different markets without any vertical relationship. And these kind of combinations or firms produce different but related products or purely conglomerate combinations they form. And these conglomerate combinations we can look into, there are three ways of classification, that is the combinations between complementary products, combination between neighboring products and combination between unrelated products. All these can be the different categories of conglomerate combination. And what are the objectives? So, object of the objections or the negativity about this conglomerate merger, they create deep pockets which enable the firm to devastate the rivals. They have the deep impact in the market, then lower cost and the margin will be very less. So, the industry they can push to the industry to very marginal cost, then barriers they can make barriers to the entry of new entrants, then reciprocal dealings to the disadvantage of the rivals also they can make, then ultimately they can eliminate the potential competition. So, in the combinations which we discussed about is the combination can be or merger, acquisition and amalgamations can be done by the enterprises, but if it is for the purpose of eliminating competition from the market, definitely it is going to be under the purview of the Competition Commission of India. And the threshold in India under the competition law, the threshold limits are mentioned under the 2011 regulations. Once each and every merger, acquisitions, amalgamations and other form of joining entities together is always under the purview of Competition Commission of India, specifically especially if it is for the purpose of eliminating competition from the market, if the objective is to eliminate the competition from the market. So, in the whole week, if you summarize, and we were talking about the basics of competition law, which we started it from the historical perspective, especially in India, how it is started, where it is started, and the developments in the post independent India, the constitutional provisions and various committees appointed by the government to ultimately leads to the formation of a bill, and then that bill become an act in 2002 and the enforcement from 2007 onwards. And then we looked into the developments of the cardinal principles of the competition law, all the three cardinal principles which we covered in this particular week. So, in the first week we talked about the introduction to intellectual property law. We looked into all categories of intellectual property. The second week we looked into the basics of competition law, and the third week we are going to look into the interface between competition law and intellectual property law, and then finally, the US jurisdiction as well we have to look into. So, as I hope that the interface, in order to understand the interface properly, the students has to complete these two realms, one is intellectual property and other one is the competition law. Then it will be easy for you to understand the interface between these two areas in the coming classes. So, we will come with the interface area from next week onwards. Thank you.